or concerning the relationship between the central authorities and the region, to the NPCSC for interpretation in accordance with Basic Law 15H3 if the conditions under the provisions are satisfying. Most importantly, whether to refer to the NPCSC for an interpretation is a decision to be made by the CFA in accordance with our common law. Therefore, there can hardly be any damage to the rule of law or jeopardizing of our judicial independence. It is exactly because of the consideration of judicial independence that the DOJ had not publicized the way in which the FDH case is being handled. In the past, as in the Congo case, the CFA had referred to the NPCSC for an interpretation of the Basic Law in accordance with Basic Law 15H3. At the time, the two legal professional bodies, the legal profession and the international community, generally recognized that such measure would not affect judicial independence or the rule of law in Hong Kong. As I have repeatedly stated on other occasions in the past, this government absolutely respects the rule of law and judicial independence. We will adopt the same cautious attitude in handling the FDH case and the mainland pregnant women problem. Therefore, I do not agree that DOJ's handling of the FDH case would bring on turbulent storm to the rule of law of Hong Kong. Finally, I would reiterate that the request by the DOJ for the CFA to consider referring to the NPCSC for clarifying the effect of the 1999 interpretation under Basic Law 15H3 would absolutely not affect the rule of law and judicial independence of Hong Kong. On the contrary, this measure would hopefully assist to resolve the right of abode issue of different categories of persons, including foreign domestic helpers and babies born to mainland pregnant women. This is also consistent with the idea that I have emphasized in the past, that is, to resolve the relevant issue under the legal system of Hong Kong. 多謝。
明明基本法明釋法咧係適用於國防外交或者中港事務，但係呢個入境條例或者居留權明明係香港自治事務，點解都要建議釋法？咁樣釋法以後係咪完全冇底線，乜嘢都可以釋法咧？第二，其實呢單 case 上訴嘅時候，就算法院話99年嗰個釋法係唔啱用，都判咗政府贏，政府點解都仲要建議釋法？明明好有贏面，係咪一個藉口，順便解決埋雙非問題兩個問題
？OK， 首先呢個絕對唔係一個藉口。響呢一個菲傭，我哋響呢個外傭案件嘅時候呢，無論響原訟庭或者係響上訴庭嘅時候呢，當其時政府嘅代表嘅資深大律師係好清楚咁樣呢向法院係講咗，我哋係保留呢處理相關嘅問題嘅。咁所以呢，絕對唔係一個嘅藉口，亦都好似頭先咁講啦，就係話呢個我哋覺得係有咁嘅需要，所以咁做。咁但係詳細嘅內容，由於呢個外傭嘅案件而家仍然喺司法程序裏邊呢，所以相關嘅論點嘅詳情呢，我唔可以詳述透露。至於話呢一個頭先呢位記者朋友問到話係咪冇咗底線呢？呢個絕對唔係，因為首先我哋認為呢，呢一個1999年呢個釋法嘅內容，佢嗰個效力嘅範圍究竟去到邊一度呢？其實係涉及第158條之間嘅內容嘅，因此係符合相關嘅規定，亦都最後尾決定係唔係有咁嘅需要，或者係咪符合第158條呢一個向人大常委提請釋法，係咪真係符合相關嘅要求呢？唔係我哋律政司話咗就算，係最終會係響終審庭進行相關嘅辯論，最終係好似剛講案件咁，係由我哋嘅終審法院根據香港嘅基本法，根據我哋嘅普通法去處理呢一個相關嘅問題。
而家係咪向 CFA 啊？而家係咪向 CFA 啊？而家政府。
In layman's terms, are you asking the Court of Final Appeal to seek an interpretation from the NPC before it determines the case? And if you are, are you not going back on what you said to reporters right after you were appointed when you said, insofar as is possible, cases should be resolved within the system in Hong Kong without seeking to go to the NPC?
Yes, I am not going back on my words as to how to handle the issues in questions. As I said earlier, the way to refer any issues, any relevant issues, to be interpreted by NPCSC under Article 1583 is in fact built in as part of our basic law. And it is also to go through the process filtered by the Court of Final Appeal. The Court of Final Appeal, of course, is part of our legal system. As I said earlier, although in Chinese, I'm sorry, that the final decision, whether or not to make any reference under Article 1583, that final decision, if I may stress and reiterate again, is to be made by the Court of Final Appeal and by the Court of Final Appeal alone. And therefore, that is a mechanism and a way which A is constitutional, B is being built in and enshrined in our basic law, and C is perfectly within the Hong Kong legal system.
Follow on that point. There is the question of whether you're asking the court to go back and look at a preparatory committee decision on this matter prior to the handover, which was later accepted by the NPCSC. Are you asking the court in some way to go back and consider that as a way of dealing with this issue?
No. The question of the binding nature or the extent to which it was binding, in fact, has never been previously clearly adjudicated by the Court of Final Appeal in Hong Kong. Because if you go back to the case of Zhang Fengyun, in fact, there is a point which there was an express paragraph in the Court of Final Appeal judgment. That point was not argued. It was being simply proceed on the basis of both parties' assumption as a result of a concession made by the government at the time. Therefore, if I may make it absolutely clear that that was a point which has never ever been adjudicated by the Court of Final Appeal. Therefore, there is no questions of going back. And also, if I may say that at the end of the day, whether on the questions of making any references to the NPCSC under Article 1583 or how that is to be dealt with or approached, the final decision is to be made by the Court of Final Appeal upon hearing submissions by both parties. Therefore,
透過修改基本法或者入境條例去解決呢個問題，同埋有冇評估過如果法院去拒絕政府今次嘅要求，你哋有冇下着咧？同埋點解要等包致根法官離開咗即係終審法院之後，先至作出今日嘅行動？
嗱，首先我以前都同大家傳媒嘅朋友講過，就係有關處理雙非問題嘅所有嘅方案呢，我哋律政司內部係每一個都曾經係作過詳細嘅研究，亦都上次我喺廣州會見傳媒嘅時候呢，亦都有講過呢，就係話呢係就相關嘅問題呢，係有請到外間嘅包括香港嘅資深大律師同埋英國嘅御用大律師，係就相關嘅問題提供專家嘅法律意見。咁呢一個方面呢，其實我哋係每一個都係有考慮，包括呢位記者朋友頭先提及嘅呢，我哋都係有考慮過嘅。時間上面嘅關係呢，絕對同頭先呢位記者所講嘅呢完全無關。我可以同你保證完全無關，因為呢究竟日後呢一個嘅外傭案究竟係邊一個法官聽，我哋律政司係完全冇得控制。第二，外傭案件幾時聽，亦都唔係我哋律政司可以控制嘅。我哋純粹係就相關合適嘅案件，響香港基本法同埋其他法例下邊可以容許嘅情況之下，做我哋認為響法律上邊適合嘅事情，亦都絕對係唔存在任何向法庭施加壓力。呢一度或者我希望澄清就係今次呢一件事呢一個方法向外間透露呢，唔係我哋律政司透露嘅。我今次出嚟同大家講述呢一個情況，係因為我見到今朝嘅報紙係唔知點解喺咩情況之下 呢一個問題，呢一個情況係向報界呢一個係披露咗。咁我亦都知道報紙或者係其他嘅傳媒呢非常關注呢一個問題，所以喺咁短嘅時間之下呢，係唔好意思喺咁短嘅時間之下，麻煩大家嚟到呢一度同大家係簡單咁去解釋呢一樣嘢，所以係絕對唔存在任何嘅壓力，亦都呢，或者我希望喺呢度重申就係話，正如我頭先咁講，日後究竟係唔係就呢一個問題向人大常委尋求呢一個就1999年釋法作出一個澄清呢？呢一個決定係我哋香港終審法院嘅決定。我亦都希望大家呢係對我哋香港終審法院嘅法官係有信心，佢哋會知道呢係點樣去處理呢一個問題嘅嚇。
政府呢個方面咧，其實包唔包括其他嘅建議啊？係咪只係建議咗係可以提請人大釋法？因為咧亦都有啲學者提出，其實係可以自己法院去自我修正。咁係咪會更加合乎司長所講嘅，即係喺本地嘅法律體系裏面做呢一件事？
嗱，我頭先講得好清楚，今次呢，我哋向終審法院請求佢考慮就根據基本法158第3款嚟到去提請人大澄清呢個1999年呢一個釋法呢，純粹係因為我哋響處理外傭呢一個案件嘅時候，我哋覺得無論係響法律同埋相關法例嘅考慮之下，係有需要，亦都係合適咁樣去做。我哋唔係好似外間有某啲嘅傳聞，係話借呢一個案件呢，係希望呢去做到一啲其他同呢一個法律上邊唔符合，甚至乎係有矛盾嘅目的。因此，我哋係引用呢一個1583，響外傭案件引用1583嘅時候呢，我哋係希望呢係就翻外傭引起嘅法律嘅問題，係嚟到去考慮係咪需要就1583呢一度向人大提請。所以呢個呢係唔存在頭先呢位記者朋友所問嗰個情況，亦都我希望再重申一次，絕對係唔係有任何嘅意圖向法院或者任何嘅司法人員係施加壓力，呢一個絕對冇咁嘅意思，亦都正正係因為咁樣樣，所以我哋一路冇響公開場合去提呢一個問題。今次我出嚟講，我再重申一次，係因為唔係我哋律政司透露咗呢一樣嘢，喺我哋唔清楚嘅情況之下，呢一個情況呢一個消息係向外間披露咗，所以我先至會出嚟澄清。
會影響到莊豐源案㗎嘛？即係如果到時真係釋法嘅話，係會影響到莊豐源案。咁變咗，其實今次係咪一個壞嘅先例？即係你哋律政司要求終審法院去令到佢哋要提請釋法嘅話，去影響翻佢之前判過嗰一件案件。
我可以好肯定咁話俾你聽，呢個唔會係一個壞嘅先例。點解呢？希望大家了解就係好似頭先我咁講，係唔係向人大尋求呢一個澄清呢？首先係由呢一個終審法院嘅法官自己去決定。咁當然喺決定嘅過程裏邊呢，法官亦都會清楚呢，就係向人大尋求釋法嘅時候有可能出現嘅情況。第二就係話我諗大家都會知道，喺我哋普通法嘅制度下邊，先例當然係非常重要，但係亦都唔係話未試過呢，法院響認為適當嘅情況之下呢，唔係100%依循以前嘅先例嘅。咁呢一個咁樣嘅情況，若果係由法庭自己響考慮過所有相關嘅法律、所有相關嘅案情之下，決定咁樣做嘅話呢，呢個唔會係一個壞嘅先例。呢一啲事情以往喺香港嘅法律制度，喺其他普通法嘅法律制度之下，亦都係試過。最重要嘅，大家要了解就係話呢一個改定唔改嘅決定，唔係由行政機關去做，而係由司法機構自行決定去做。呢一點呢係完全符合我哋香港嘅法治，亦都唔會呢係同頭先大家講或者問嘅問題裏邊話有乜嘢係開壞呢一個先例啊，或者係構成呢一個壓力啊。呢啲呢 係唔會存在，希望大家呢係明白。
已經有先例嘅效果做咗出嚟，你哋會唔會